Dale Pike. Eagle Armstrong. Louisa Rhodes. Melanie Swift.
You're doing just like I'd hoped. You fill from the wall towards this way. And as you come down here, I'll give you.
Rodriguez Barajas.
No, I apologize.
Hooray, Gray Band. Ricky Mock. Sarah Stevenson. Randall Burns. Haley Leopis. Margaret Wood. Alexis Sharp. Nicholas Thompson. William Schneiders. Michelle Knudsen. Daylon Cooper. Catherine Clayton. Jaden Pacheco. Kimberly Brockhoff. Kelly Hess. Patricia Gonzalez. Elizabeth Brown. Christopher Niehaus. Diane Widner. Don Lefebvre. Jesse Peterson, Linda Hamilton Downey, Michael Holder, Caitlin Shager,
And so those of you in this front row will probably have to relocate somewhere behind for right now, so.
Amanda Overly, Sarah Wolf, Scott Hendrickson, Robert Dessing, Maurice Byers.
Okay, well. All right, well, let's see if we can find a chair somewhere. I don't know if we can or not, but otherwise we can pull one out of the chambers package.
We have a chair.
Okay, great. I know, and good. Those of you that want to have a seat, feel free to do that. So I want to just do one more thing, and I'm going to turn this over to, first of all, to Mr. Loomis. But if you would be so kind as to just turn your numbers around this way. And I know the numbers are somewhat different, and I'll just explain that real quick. We obviously went through whatever the number was, last number over there was. But as we went through these questionnaires, we sorted out some folks that we excused, but we didn't change the number that you got assigned to you when you checked in, when it was randomly assigned. Just so that's why there's some confusion with numbers. So council may refer to your number. I may ask you for your number, or I may just confirm your number, because we're making a record of this and I need to make sure that that matches up with the individual that we have on the list over here. So Mr. Loomis, I'm going to let you begin.
Thank you. Good afternoon, ladies and gentlemen. My name is James Loomis. I'm the Woodbury County Attorney. I appreciate everyone being here this morning and filling out the questionnaire. Believe it or not, that did help facilitate a lot of what we're going to do during this particular process. So I really appreciate your time and your patience. As I know Mr. Lose, Mr. Mulford, and Mr. Parker do as well. I want you to know that this process that we're going through somewhat feels as if you might be on the hot seat because we're asking you questions about different things. Really, the purpose of what we're doing here this afternoon is simply trying to find and make sure that the jury that's selected to hear this particular case is suited to listen to all the evidence, make a decision based on the evidence presented, and to make sure that you, if you are selected, are a fair and impartial juror. And what that means, like I said, is simply being able to sit, listen to all the evidence, and then make a decision based on the evidence that's presented. And so when somebody asks you, if it's myself or somebody else during this process, that we need to know if you can be fair and impartial, that's really what that means. And so I want you to know and understand that, you know, while it may feel like you're on the hot seat if you're being asked a question, it's simply for that purpose. We're trying to make sure that we have a jury for both sides that can be fair and impartial. Now, if at any point during this particular process, if you are asked a question that makes you uncomfortable in answering that question in front of the other potential jurors, then please let us know. We can take those things up outside the presence of everybody else. The intention here is not to embarrass anyone with any question or to pry into anyone's personal life. Again, simply the effort being made by both sides here this afternoon is to select a fair and impartial jury for this particular case. Now, if you're not selected, or if you're excused for some particular reason, it doesn't make you a bad juror. It just means that you might not be best suited for this particular case for any number of reasons. And so I just want you to know that going into this process. And so at the end, when everything is done, you kind of have a better understanding of maybe what has taken place, why we were doing what we were doing, and understand that, you know, if you don't make it for any particular reason, it might just be because you're better suited for a different trial and not necessarily this one. Okay. And so please, again, if there's anything that concerns you or would embarrass you in any way, please let me know that so that we can take that up outside the presence of the jury. Now, I know that the judge asked you this before we started, and I know that it was in your questionnaire, but how many people have served on a jury before? If you can raise your hand for me. Okay, so we've got juror number 7, juror number 11. We have juror number 15.
Then over here, 33 and 55.
33 and 55. Thank you, Your Honor.
53, sorry, I misspoke. 33 and 53.
Of the jurors that served before, how many people were on a criminal case? Juror number 7, 11, 15, and 53. Okay. How many people that have served on a jury before would tell me, James, don't want to have to serve on a jury under any conditions. They just don't want to do it. And that's fine if that's what your opinion is, and that's okay. If you don't want to be here, right? And it's just, you're adamant about that. That's all I want to know. If that's you and that's what you're thinking, if you can let me know that. Is there anyone that would think that, of those that raised their hand? Okay. Of those that served on a jury before, how many would say that it was a good and or interesting experience? Juror number 7, 11, 15, 33, and 53. Okay. So none of you had a bad experience or what you would say was a bad experience before. Okay. Now, some of what the judge asked you before you got called up was he was talking with you about reading jury instructions to you. And the jury instructions are simply your guide as the fact finder. So during this particular case, as with any case, evidence will be presented to you. And that evidence, you gather it all together, it gets submitted to you. And then you guys take that evidence that's presented to you. You take the instructions that the judge gives you, which is the law that you're to follow. You apply the law to the evidence, and then you make a decision based on the evidence that's presented to you. Now, one of the things that the judge talked about was that he talked about an instruction that you're going to hear regarding credibility and how you assess credibility. And the reason that you get that instruction is because, as you might expect, and as we all kind of can know, is that during the course of a trial, there's going to be witnesses that come and they're going to sit in that chair right up there. And if you're selected as a juror, they're going to sit down, they're going to take an oath, and they're going to testify. And you listen to that, and that's considered part of the evidence that you'll receive. And part of what the judge said in terms of this instruction that you'll get at the end of trial is assessing each and every witness that comes and testifies, that you'll assess each and every piece of evidence that gets presented before you. And you'll evaluate all of that, put it together, and then it's your job to make a decision. But most specifically regarding that particular instruction is something that I always want to talk with potential jurors about. And that's not just the concept of credibility. right? And weighing and assessing credibility, because that's something that you'll have to do. Is there anyone that would have, that they would think that they would have difficulty doing that just generally? Is there anyone saying, you know, for whatever reason, I would have a hard time in assessing somebody's credibility if they took the stand and testified? Okay, good. When you do that, that's what I want to talk about. The process of assessing credibility, because we all do it every day, whether we realize it or not, we are doing it. And we all probably do it a little bit differently. But even though we probably all do it differently, there are certain things that we're probably all evaluating in that process. And so what I want to do is talk a little bit about how we assess credibility, what's important to you individually in that particular process that you go through. Because as you might expect, the process that you probably do on a daily basis, you will bring into this process, and you'll do it when you sit and listen to all the witnesses that testify, when you sit and take in and examine all the evidence that's part of this case. And so I want to talk with a few of you, not everyone, but I want to talk with a few of you about kind of what that process is like for you. And I think I'm going to start, and I'm going to bounce around a little bit. So I'm not going to go in order one right after the other. So you kind of be unexpected for who I'm going to pick on, I guess. But I'll start with Miss Swift, juror number 37, right, Miss Swift? How are you doing this afternoon? Good. I appreciate you being here. When we talk about the concept of credibility and how you assess credibility, how is it that you go about that process? What's important to you? How do you make those assessments, Miss Swift? Okay. Why is eye contact important to you? Okay. And what did you say? Gut reaction? What do you mean by that? Okay. So their attitude and their body language. What about body language? Anything in particular? You said eye contact. I would consider eye contact body language, but is there anything else that's important to you about body language? The reaction in general. Have you ever testified before, Ms. Swift? Okay. Do you ever want to have to testify? I can appreciate all of those sentiments, Ms. Swift. What I would ask you is that there may be witnesses during the course of this particular trial that have never testified before. And could you understand and appreciate that it might be a little bit nerve-wracking for that particular person to be in that chair up there and to be seated in front of what will be 14 people. And sometimes some of those tendencies that we get when we're nervous become a little more exacerbated. Would you agree with that? And so it may be more difficult for someone to maintain eye contact than normal simply because of nervousness, or they might be somewhat fidgety because of the nervousness. Would that be something that you would take into account, knowing and understanding that it might be a little nerve-wracking for that particular witness? Okay. Thank you, Ms. Swift. I appreciate that. Mr. Mott, am I saying your name right?
Wow.
How are you doing this afternoon?
Wonderful.
Good. You are juror number 7. Now, you've been a juror before, and you've gone through this process, and you had to kind of evaluate witnesses before. And so you have a little bit of experience doing that in this particular kind of setting. What was important to you then when you were a juror, and what would you consider important now if you were selected as a juror in this particular case?
That comes that we have to listen to all of the evidence and then the instructions that you were given and put the two together, and that was not an easy process.
What was the most difficult part of that process, do you think, Mr. Monk?
And 12 us to read through a
Okay.
juror.
How long did it take for that to happen? If you know,
hours.
several hours? Was there anything that was important to you or that stood out to you about assessing credibility as you listened to the evidence and then you carried that into jury deliberation?
I think it was important for me to listen to how the inflections of their voice are. And yes, you can hear someone that's nervous, but it's kind of like in my job, I did a lot of hiring, and that's part of the process.
Sure.
as well.
Now, when you say the inflection of their voice, you talking about like in response to certain questions?
Right.
Okay, and how they responded maybe physically to certain questions? Okay. Now, Ms. Swift talked about some body mannerisms like eye contact and maybe whether they were fidgety or not or something along those lines. Was that something that was important to you in your experience before as a juror?
It's something we watch.
Okay.
Have to take into account, as you said, that sometimes it's their first time in court.
Thank you, Mr. Mock. I appreciate that. Ms. Stevenson, you're juror number 8. How are you doing this afternoon? Good. I appreciate you being here. What's important to you about assessing somebody's credibility? Why do you think, why is eye contact important to you?
I think that you're. You feel.
Any other things about body language that stand out to you? Okay. Again, going back to when I was talking with Ms. Swift, would you understand and potentially can appreciate someone being nervous if they've never done it before? Okay. Are you nervous right now?
Yes.
And that's okay. It's understandable. A lot of people get nervous talking in front of groups. It's not something that they have to do generally. And so it's always helpful to have this discussion so that people, as fact finders, because that's what you're going to be. You're a fact finder in this particular case. And it's nice to be able to understand some of this going in. And so, Ms. Stevenson, let me ask something a little more direct. You talk about body language and you talk about eye contact, but do you think it's important as a juror to come in and use their common sense? Why do you think that's important?
Just assessing what the situation was and just listening.
Okay. So that's something that you're not going to check at the door. You're going to bring that to this service as a juror if you're selected. Thank you, Ms. Stevenson. Mr. Burns, you're juror number 9. How are you doing this afternoon?
Good.
Appreciate you being here as well. Is there anything about credibility that's important to you that we haven't talked about already? We've talked about body language, eye contact, kind of body mannerisms. We talked about a little bit about common sense with Ms. Stevenson. Is there anything that is important to you?
I think the main thing that I would be concerned about is maintaining an open mind, making sure that I was hearing all the facts and assessing everything. I'm going to have my own biases toward some of those facts, but I think open mindedness is probably the key thing I look for. And I also, as far as body language is concerned, I'm just thinking before you ask me, I'm sitting here, grasping in my hand, and I think, wait a minute, do other people do that? Yeah, they do that. There's different ways of showing,
Sure.
whatever it may be. I think open mind is the key.
You said something interesting there, Mr. Burns, about your biases. What do you mean by that?
Well, we may have some preconceived notions
Okay.
about a certain type of person, a certain age of person's appearance, whatever it may be. And to be able to assess that, putting your biases aside is tough. can be a tough question.
Do you think that that's something that you can do, Mr. Burns, if you were selected as a juror? How do you think you go about making sure some of those biases don't come into play? Is there something that you can do as a juror in your mind that would help you with that process?
Well, I think what I said earlier is the key to the open-mindedness.
Okay,
You have to look at it neutrally,
sure,
and it can be hard to do at times, but
sure.
somehow you have to set some other things maybe aside. And be open-minded. I don't know, that's the key word I can think.
Sure. No, I appreciate that, Mr. Barnes. Thank you. Ms. Sharp, how are you doing this afternoon? Good. I appreciate you being here. What's important to you about assessing credibility? And what do you mean by that? Can you elaborate a little bit for me?
Whether the witness detail.
Do you think an eyewitness has to remember every detail? Okay. Do you think, let me ask this, Ms. Sharp. So let's assume that you have two witnesses and they come in and they tell you about the exact same event. Do you think those two witnesses that gonna make you even more nervous than you are?
It's okay.
We only need to do that because Cheryl, our court reporter, just needs to be able to take everything down. So, so you listen to two people come in who've seen an event. And do you think those two people are going to tell you the exact same thing?
No, not necessarily.
Right.
No, not necessarily.
Okay. Why not?
Because everybody experiences things differently.
Okay. And when you say everyone experiences things differently, can you be a little more elaborate about that? What do you mean by that?
Just how they feel or they take it in.
Okay.
They can see it in a different light.
Okay. Let me switch it up on you just a little bit. Let's say that this particular event that happens, that these two people came in and told you about, that one person is standing on one side of the street and another person is standing on the other side of the street. So neither person knows each other. Let's just say it's just this event that happens. These two people just happen to be standing there on opposite sides of the street. Is there anything that you can think of about why their version of this story might be different?
Well, I mean, just on the aspect of they're on different sides of the street.
Right.
It'd be completely different.
They're on different sides of their street. So their perspective might be different, right?
Yes.
Their vantage point of what they saw might be different. Maybe one person's view is blocked at one point in time during this event, but is clear during the rest. And the other might be blocked during part of it for a car or something that's in the way. But do you think if you were selected as a juror, Ms. Sharp, that you could reconcile those two witnesses to the same event and say that I can still find them credible, even though their versions of the same event might be somewhat different?
Yes.
Okay. Is that something that you are comfortable doing?
Yes.
Okay. You want me to stop asking you questions now? Okay, you can pass the microphone over to, let's do Ms. Wood, juror number 11. Good afternoon. How
Good
are you
afternoon.
doing?
Good.
Good. So you've been a juror before too?
I have.
So this process of evaluating credibility and assessing credibility is something that you would have done before. Is that fair?
Yes.
Okay. How did you go about that process?
Listening to all the evidence and taking into consideration the instructions and then just working through the process.
How do you work through the process?
It was such a long time ago. It's probably been
Okay.
more than 25 years ago that I sat on the jury.
Okay,
So it's really been a long time ago.
it's been a long time. Okay, so let's go back to the hypothetical that we were just talking about.
Mhm.
With Miss Sharp and there's two witnesses on opposite sides of the street.
Mhm.
And they come in and they tell you what happened. And what they tell you, they've seen the same event, but what each says might be somewhat different than the other. Can you think of any other reasons why those versions of the same event might be different beyond what we talked about before? Perspective, specifically standing on different sides of the street, or kind of how they were feeling that day, what they were thinking that day. Is there anything else that you can think of?
And in this scenario, did one of these people know anyone involved?
Well, let's assume that they did.
If there was some sort of,
Sure, let's assume that for purposes of what we're talking about, that one of the people that saw this event that's telling you did know one of the persons involved in this particular event that they're observing. Does that change anything for you?
I would make the assumption that it would be skewed toward the innocence of whatever happened because it wasn't his fault, it was something else.
And why do you think that? Why do you say that?
Because of that friendship, because of that knowing of the other person. You stick up for your brother, you stick up for your person, your friend.
Do you believe that's the case? Even if the person comes in and is swearing to tell the truth under oath? Do you think that makes a difference?
I would hope so,
Okay,
but
sure.
I would hope so.
Okay, it's a consideration that you have anyway.
Yes.
Is that a fair way to
Yes.
say it?
Yes.
Okay, thank you, Ms. Wood. I appreciate that. Can you hand the microphone to Mr. Schneider's juror number 14? Good afternoon, Mr. Schneiders. How are you?
I'm good, thank you.
Good. I appreciate you being here. Do you have children, Mr.
No, I don't.
You don't. Okay. What do you do for work, Mr. Schneiders?
I am a computer security administrator at Great West Casualty.
How long have you been doing that, Mr. Schneiders?
I transferred into this job about a year ago at Great West.
Are you from this area originally?
I was born here, yes.
Okay. What's important to you about assessing credibility? We've had some discussion thus far. We've had an example, kind of about how you assess it in a situation where you've got two people seeing the same event. But what's important to you about that assessment process?
I would say for me, it would be consistency.
Okay. Why is consistency important?
Well, if you ask someone a question and they answer it one way, and then later on you maybe ask a similar question and they answer it a different way.
Okay.
Then I would have some doubts about that.
Why would you have doubts?
Because I think in my opinion, if someone is telling the truth, they're going to be consistent. Their story won't change.
Have you ever told a story to a friend about something that happened to you?
Oh, sure.
Have you told that story more than once?
I'm sure I have.
Do you tell the story the exact same way every time you tell it?
I think I do. I
Okay.
don't intentionally try to change it.
The substance of your story stays the same.
Yes.
Would you agree that maybe the words you use or your mannerisms of how you describe it may change depending on the day of the week that you tell the story?
Yes, I would agree with that.
But ultimately, I think what you're talking about, Mr. Schneiders, is that consistency that you're talking
Mhm.
about, you're talking about the story and what happened doesn't change. Is
Correct.
that what you mean by that?
Yes. Mhm.
Okay. Would everyone agree with that and what Mr. Schneiders is saying about consistency in terms of now the story and the guts of the story, as I'm going to call it, the guts of the story stays the same, but maybe there might be how the person says it or the words that they use to describe it might change a little bit depending on when you tell the story and who you're telling it to. Does that make sense to everybody? Thank you, Mr. Schneiders. I appreciate that. Could you pass the microphone back to juror number 43, Mr. Cooper? Mr. Cooper, how are you doing this afternoon?
Good, how you doing?
I'm good. I appreciate you being here. What's important to you about assessing credibility?
Listening to all the evidence and basically breaking down every key point and looking at it from all angles of the people that's involved.
And we had the hypothetical just a little bit ago with Ms. Sharp about the two people on opposite sides of the street
Mhm.
having different perspectives of the same event. When you're talking about listening to all the evidence carefully and making that evaluation, would you agree with me that two people who see the same event because of perspective or vantage point might see something a little differently?
Yeah, and then no, because if you're across the street, depending on how far you down, I'm gonna say that. If you're across the street, you kind of see the same thing depending on what you're seeing.
Sure.
Some people might have a different perspective of what they seen, but it's kind of the same. It's going to be the same.
Okay,
If you're seeing basically the same thing, it might be a different word of what you use, but it's the same. Y'all see the same thing.
okay. And we were talking about consistency with Mr. Schneider's just a moment ago.
Mhm.
Is that something that you agree with in terms of
Yes.
consistency being important?
Mhm.
Well, let's think practically, Mr. Cooper. I'm going to take my glasses off. Do you think that I can still see you?
A little bit.
Okay. Who here, if they take their glasses off, would say, I can't see anything? We don't have very many glass wearing people here. Okay. So practically speaking, what if one of the people that's standing across the street wasn't wearing their glasses that day? Think that's important to know?
Yes.
Okay. Think that's going to maybe change how well they saw what they saw?
Yes.
Okay. So that's just a practical maybe example of something that would impact what somebody says about an event that happened. But when you say you want to kind of review it from every angle, I think you're a detailed person, Mr. Cooper, or it sounds like you are in assessing those things. And so maybe wanting to know whether someone has their glasses on or not, that might be something that's important to you, and it might be something that's important to some of the other folks as well.
Yes.
Okay. Thank you, Mr. Cooper. I appreciate that. When you pass the microphone ahead, Mr. Cooper, to juror number 17, Miss Clayton. One more. Good afternoon, Miss Clayton. How are you?
I'm good.
Good. I appreciate you being here this afternoon. We've been talking about credibility a lot with the group thus far. Is there anything that's important to you about credibility that we haven't talked about already?
I don't know. It's basically when you're talking to someone, it's like the eye contact, and you have a gut feeling of whether they're being truthful with you.
Do you have children, Miss Clayton?
No,
Okay.
I have a lot of nieces and nephews.
You have a
that
lot of
try that.
nieces and so, okay, so let me ask you this, Miss Clayton. You're talking about a gut reaction. Have you ever been in a situation with your nieces and nephews where you have to settle a dispute of some kind?
Yeah,
Somewhat?
somewhat.
Would you agree with me, Miss Clayton, that it's sometimes easier to figure out what's going on if you know the people that are involved?
Absolutely.
Okay. Now, in this particular setting, under this kind of situation, if you're selected as a juror, that's probably not going to be the case.
Absolutely.
I don't remember exactly what you put in your questionnaire, but we had a list of a whole bunch of people.
I didn't know
You
anybody.
didn't know anybody. Okay, so you're not going to know any of them. Do you think that process makes it any more difficult for you if
Yes,
you were
it
selected
does.
as a juror?
It does make it more difficult
Okay, how does it make it more difficult?
because you don't have a history with those people. You don't know those people. You won't know that gut feeling. You're not familiar with them.
You're not familiar with them. So would anyone agree with Miss Clayton that they would feel the same way, that it's more difficult if you don't know the people? Everyone? Generally, kind of everyone agree, a lot of nodding the heads, okay. So knowing going into it, that that's probably gonna be the case for you, Ms. Clayton, is that something that you can do?
I can try.
Okay. Do you think you're still gonna have gut reactions to what you listen to, what you see, what you may have as part of the evidence in this case? Do you think that that's still gonna be part of your evaluation process?
I think so.
Okay. Thank you, Ms. Clayton. I appreciate that. Can you pass the microphone over to juror number 18, Ms. Pacheco? Am I saying that right?
Yes.
How are you this afternoon?
I'm okay.
Good. I appreciate you being here. Is there anything else that you can add to our discussion about credibility and how you assess credibility?
I don't think anything to add, but maybe reiterate how, I'm sorry, I'm blanking on the word. Consistency.
Consistency. Okay.
Yes, I think that though stories may change in little bits, like you said, they all have the same
Guts.
guts.
Okay.
Yes, and so.
Sorry, that's not a very artful term, but
it gets
I
the
have
point
5
across.
kids, and so we talk about guts and all sorts of stuff. So, okay. But I guess, so generally, I didn't mean to interrupt you. Generally, what you're saying is that the guts or the gist of the story stays the same.
Yes.
Okay. Thank you, Ms. Pacheco. I appreciate that. Can you pass the microphone over to Ms. Brockhoff, juror number 19? Am I saying your name? Pronounce-
Brockhoff.
Brockhoff?
Brockhoff.
Okay. Thank you for being here. I appreciate it. I'm going to shift gears on you just a little bit and not talk about credibility. We've talked about credibility and how we assess credibility, but I want to talk about kind of another concept that will be part of the process that you have to go through if you're selected as a juror. And through not just what you sit and listen to and receive as part of evidence, and then you apply the judge's instructions to what you hear and receive. But there's some concepts about, what people were thinking at the time that something happened and what somebody's intention was, or what someone's thought process was at the time. And I think what you'll find as part of this process, and at the end, when there are instructions that are given to you, that you'll have to consider some of this and think about these things, about how do we know what someone was thinking at the time that something happened? Do you think it's possible to know how someone was thinking when something happened?
Not completely,
Not completely.
not completely.
Okay,
Without being there, I don't think it's possible.
okay. Let me give you an example, or, well, what do you mean by that? Explain to that. You say, is there some way that someone could know? Besides them telling them. So if someone came and told you, this is what I was thinking, let's set that to the side, right? And let's just say that you, as an evaluator of fact, as a juror, have to make a decision about what somebody was thinking at the time. What do you need, if anything, for you to be able to make that determination?
I'm not really sure, honestly.
Okay. Let me give you let's think of a hypothetical or an example. So let's say, going all the way back to what we talked about before with this example of this event that happens. And we have 2 people on opposite sides of the street and they see different things of this event that happened. But let's say that this event that we're talking about, let's say that this particular event is where you have 2 people who get involved in a fight. Someone comes up to the other, strikes him in the face, and that person goes down. The guy that struck the other person in the face, do you know what his intention was there?
To knock him out.
To knock him out, right? Why do you say that?
That's what he attempted to do.
because he did it, right?
Right.
So you can know what someone's intention was. You just might need to know a little bit more. Let's say in that same hypothetical that we're talking about, that these two parties that are involved in this fight, let's say that someone involved in this particular situation is just angry, and you can see it, and you can just read it, right? You've seen people who are angry before. You can tell when someone's not happy,
Mhm.
and you see this person and they make a beeline for this other person. Do you know what their intent is there?
Probably to harm them.
Probably to harm them. Let's add something to that. Let's say that they're making a line towards that particular person and they're angry. And they say something. They make some sort of comment about, I'm going to get you. Something to that effect, right? Are you more confident in what their intention was then?
Yeah.
Going back to the other example where you just say that they're angry. You can't say that they're going to hit them, right?
Right.
But you're making deductions based on what you've seen. And you add something to the pile about what they say,
Right.
right? Do you think you can know what their intention was based on just how they appear and what they say?
I don't think so.
Okay, you need to be able to see everything that happened to know exactly what their intention was.
Right.
Okay. How many people in the group here would agree with that? That they have to kind of see the end result for them to know exactly what somebody's intention was? Does everyone agree with that? No. Who disagrees with that? Okay. Let me keep your hands up. I'm going to pick on you now. So, so we have juror number 41. Juror number 49. 50. 31. 33. Mr. Schneiders, you just must want to be picked on here. Let me ask that. So is it Braban, juror number 41? Okay. Tell me about what your thought is regarding that. And now we're talking about whether or not you can know what somebody intended. So kind of explain for me what you mean by that.
So a person would be angry, they could be, lashing out saying, hey, I'm going to get you out back after dark.
Mhm.
But they're never gonna follow through.
Okay.
They want to make them back off the situation.
So what do you think their intention is? Just back off?
To get the other person to stand down.
Okay. Juror number 14, thank you. Mr. Schneiders, what do you think? Sure. So we're talking about how we know, or can we know what someone's intention was?
No.
Okay. Under any circumstances?
Maybe under some circumstances, but sometimes someone's intention may be just to get someone to stop doing something, but what happened was worse than
Okay.
that. And you have to take a case by case.
Sure. So the example that we were talking about, we talked a little bit about someone's appearance and then being angry. And then we talked about them saying something about, I'm going to get you or something along those lines. Do you think that in and of itself can get you to a point where you can figure out what someone's intention is? Okay. You're in agreement then that you need to kind of see the entire event happen? Okay. Thank you, Mr. Schneiders. Ms. Shager, juror number 49. How are you doing this afternoon? Good. I appreciate you being here. Tell me what your thoughts are on those situations, that hypothetical that we're talking about.
Oh, I'm not able to hear.
Can we pass the microphone over to her? Thank you.
What's the actual question that you're asking?
So my question is, we're talking about how do you know what someone's intention is?
When they flat out tell you, I'm going to do this, or they basically just tell you, Otherwise, you never know what someone's intentions are.
So you think somebody has to tell you what their intention is for you to know?
No, but they can, yeah, kind of actually.
Okay. Do you think in the example that we talked about where a person approached another person and struck them in the face, do you think you can know what their intention is there, even though it
How
didn't say-
how they were approaching them, yeah. Like if they were walking up to ready to, you know how you can tell when someone's about to hit you,
Okay,
you know?
so let's say that they walk up, they're angry, you've heard them say something, swing their fist back, and you're one of the people and a car drives in front of you. And you don't see anything that happens after that. And you see the car passing and the person on the ground. Do you know what happened?
I would assume,
Okay, why do you assume you would know what happens?
because just the car took a second to drive by.
What are you doing in your mind to get to that conclusion?
Analyzing the situation that was happening before the car drove by.
Good. What are we talking about there? We're talking about common sense, right?
Mm-hmm.
You can take your common sense and your experience that you've had. I won't ask how old you are, but you're younger than me. So you can take your experience over all the years, right?
Mm-hmm.
And you can bring that in and you can make assessments about things that happened.
Yeah.
Even though you may not have actually seen him hit the other person,
Mm-mm.
you can draw that conclusion fairly because you've got enough facts to go by. Is that fair?
Yeah.
Okay. Can you hand the microphone over to Miss Oberly, juror number 50. How are you doing this afternoon?
Good. How are you?
Good. Do you think we can know what someone's intention was?
No,
Okay. Under any circumstances?
not really. No.
Why do you think that?
The example of punching someone, they might not have meant to punch someone. Just because
Can you say that again?
they might not have meant to punch someone. Maybe they were joking or they got too angry and they punched someone,
Mhm.
but it might not have been their intention because I don't think I truly know 100% what someone is feeling.
Okay. What are you talking about in that situation? So you're changing our situation a little bit,
Okay.
right? Because you're talking about a situation where in our hypothetical, you're talking about two people, one's visibly angry, they're approaching the other person. You see them, let's just say that you see them bring their arm back. Do you think in that situation, you know what's going to happen?
Yeah.
Okay. Your situation, the context, I'm going to use the word context, is a little bit different, right? You're essentially telling us that an accident happened,
Mm-hmm.
right? So what you're talking about, correct me if I'm wrong, is you want there to be some context to the situation that you are listening to these two people talk about. Is that fair?
Yes, there needs to be some understanding of what is going on.
Okay.
I can't just see someone punch someone else and automatically know if it was wrong, if it was right.
Okay.
I think another situation I'm kind of thinking of is if someone is approaching someone else angry and says, "I'm coming for you." And then they get up to the person and they both start laughing. Again, you kind of have to see the whole picture
Right.
to truly understand what happened.
So let's use the example that Ms. Schneider's is talking about, where car drives right in front of you,
Mhm.
right when everything's about to happen. And the car drives by, you see the guy on the ground. Do you know what happened in that situation?
I agree that common sense would tell me
Okay.
what happened. Yes.
Okay. And what you're telling me, correct me if I'm wrong, is that you still want some sort of context behind that whole incident, because from what you're telling me, maybe that it was an accident. but you didn't see that part because the car drove in front of you,
Perhaps.
perhaps? Okay. Well, I appreciate that, Ms. Oberly. Thank you. Could you pass the microphone over to juror number 31, Mr. Is it Wolf?
Yep.
How are you doing this afternoon, sir?
Good, thank you.
Good. I appreciate you being here. What did you want to add to the discussion about knowing whether, what someone's intention was?
In my professional career, I deal a lot with behavior, and specifically, all behaviors have a purpose and a function. And I truly believe that in order to understand what the purpose of an incident or a situation is, you really have to understand the function of that behavior and what truly was the root cause of the behavior. For example, in my profession, I work with people with significant trauma and things like that. And so I truly believe that when we're talking about individual people, their behavior is an outward expression of communication, and they're communicating something different, and it just is, it's individualized per person, and you really have to understand what the function of that behavior is and what the purpose of that behavior is. If that makes sense.
You said a lot there. Do you think that you have to see the behavior to know?
You do not have to see the behavior to know.
Okay.
No.
Do you think that you can know based on what someone has said?
I think if we talk about credibility and you look at resources and testimony and experts in the field, that there is you can make some assumptions.
Thank you, Mr. Wolf. I appreciate that. Can you pass the microphone forward to juror number 47, Mr. Nihas?
Yes, sir.
Good afternoon, Mr. Nihas. How are you doing?
Doing well.
Good. I appreciate you being here. I have just a little bit more that I want to talk with you about. One of the things, and I talked with Ms. Schneiders about this, or Ms. Shager about this, is kind of knowing and drawing conclusions, even though you might not have seen something. And it's a concept that will go into another jury instruction that you'll receive at the end. And it's an instruction that defines the different kinds of evidence. There's direct evidence, and direct evidence is essentially evidence from a person that has personal knowledge of an event, such as an eyewitness. Somebody sees something, they come in and testify about what they saw. So that's an example of direct evidence. But there's also evidence that's called circumstantial evidence. And circumstantial evidence and direct evidence, as you'll get the instruction from the court, are both kinds of evidence that you can consider if you're selected as a juror in this particular case. And you can weigh both kinds of evidence in that evaluation process. But I want to talk a little bit about what circumstantial evidence is. Circumstantial evidence, and I'm going to give you a hypothetical. It's a little different than the hypothetical that we were talking about with the two people across the street. But let's say, do you have children?
Oh, yeah,
Okay, how many children do you have?
too many.
Two.
Four.
Yeah.
And they're all grown up.
You have
So now
grandchildren
Now
too?
we've got grandkids.
Okay, that's a good deal. So let's rewind the clock and say that you come home from work and you see that the counter is a mess, that the peanut butter's out, jelly's out, and there's a plate out, a dirty knife, and a dirty spoon. Breadcrumbs all over the counter. Anyone can relate to this hypothetical? Yes, okay, good. It's not just me. So let's assume that you come home and you find that. And so you're trying to figure out who it was that got into the counter and got the stuff out and had a snack. You would agree with me that you didn't see which child it was that got into it and got the snack, right? Okay, so you bring your children in and you line them up and you're trying to figure out who did what. this is a situation that I face almost every day. And so what you find is you've got one child doesn't have anything on their face. Second child doesn't have anything on their face. Third child, you get to, they've got sticky fingers and they've got peanut butter smeared on their chin. And they tell you, Dad, wasn't me. What conclusion do you draw?
Sorry, son, it was you.
It was you, right?
The evidence says it's you.
The
buddy.
evidence says it's you. And it's a simplistic example, I know. But that's an example of circumstantial evidence. You don't have an eyewitness. I suppose you could have, maybe you could have asked one of your other kids if you saw it. But in this particular situation, we don't have that. What you have is a situation where you see certain things, a chain of facts. I'm going to call them facts because that's really what they are. You're making observations about things being out on the counter, observations about your son and what he's got on his face. And you're putting those things together to lead you to a conclusion. And that's what you do with circumstantial evidence. Circumstantial evidence, what you'll see in the instruction is that, as it's defined, is talking about a chain of events or a chain of facts that leads you to a conclusion that you can rely upon, because those chain of facts that got you to that conclusion are reliable. Does that make sense to everybody? Okay. Well,
In that particular scenario, though, that circumstantial evidence is reinforced by some physicalities there. I mean,
sure.
you know, whereas I think there is some circumstantial evidence where you wouldn't have that necessarily have that reinforcement, which makes it more difficult.
Sure.
In my case, to believe that circumstantial evidence.
Sure.
I've seen that happen. I was a supervisor of middle management. I've seen it happen time and time again between employees.
Mhm.
And as a supervisor, you're sitting there trying to determine what is actually going on.
Right.
Makes it difficult.
It does. And I think you bring up a good point, Mr. Neos. I think what you're talking about is that whatever evidence that you're using is that you want that to be reliable, right? To make a decision on whether you're in management, you're a parent making a decision between squabbling kids, or you're a juror making a decision about certain facts and whether something happened or didn't happen. So a lot of these concepts cross over to daily life, like I just kind of want to emphasize to everyone. And those are things that we want to bring into this process as a juror. And so I really appreciate everyone's time here this afternoon and answering the questions and maybe being put on the hot seat for some of it. I just have one question left, and then I'll turn it over to Mr. Los to begin his examination of you. Is that if you are selected as a juror in this particular case, can everyone agree with me that you will base your decision on the evidence that's presented and make your decision only on the evidence that's presented during the course of this trial? Would everyone agree to do that for me? Is there anyone that would tell me, Mr. Loomis, this is just something that I don't want to do. I'm not comfortable doing it for whatever reason. I don't want to make judgments about different things. I'm just not comfortable with this type of case and the information that was given to you early on. It's very limited in the questionnaire. Is there anyone that would say, Mr. Loomis, for whatever reason, I just can't be a juror. I'm not suited for this particular kind of case. Is there anyone that would be in that position? Okay, I want to thank you all for your time. I appreciate it. And the state would pass the panel for cause and turn it over to Mr. Los, Your Honor.
Mr. Los?
Thank you, Your Honor. You just keep asking.
I like to stand up. I started off being a teacher, and so when I get in front of a bunch of people, I like to move around. And so don't mind me, I'm just gonna kind of meander while I'm talking, all right? I thank you for coming today, and I know the court does, and I know Mr. Loomis, and certainly my client, Mr. Parker, appreciates your time and attention. And you've been doing a wonderful job with what Mr. Loomis asked. And between the questionnaire, question that the judge asked you earlier, and then the questions Mr. Loomis asked. I really don't have a heck of a lot of questions, but just a few kind of follow-up ones. I think we'll start with Ms. Schrager. If you wouldn't mind handing it back the microphone. Kind of follow up on the last question that Mr. Loomis had with you concerning the incident that started, and then you have a blockage where you can't see, and then there's something at the end. Do you recall that?
Yeah.
All right, so he asked all of you about common sense.
Mm-hmm.
Okay, is your common sense, is that evidence of what happened?
No.
Okay, is there anyone here who thinks their common sense or their beliefs is evidence of any kind? Nobody? Okay, now remember, I'm a teacher. If I don't start getting hands, I'm gonna call on you. All right, so now when we're looking at evidence, okay, remember what the judge told you. Whose responsibility? Need a hand? Whose responsibility is it to prove beyond a reasonable doubt what happened? Okay, how about you, sir? Okay, all right, maybe my question was faulty. Let me try again. Whose responsibility is it to prove things in this case?
The witnesses, the prosecutor.
That'd be that. That's right. So if there's something missing,
Mm-hmm.
if there's a hole, do you fill that in with evidence?
No.
Okay. All right, just wanted to make sure of that. All right. Is there anyone here who believes that Mr. Parker has to prove didn't do something? Anybody? Thank you. No? Okay. Is there anyone who thinks because he was charged that he has to prove something to you? All right, now this next one, okay. Might bug you, but it has a purpose, and I'll follow it up quickly with the next. Is there anyone here who, in the last election, voted for Mr. Okay, just keep your hands up. Just want to make sure I get 26, 30. And 2. Okay, all right. I believe he's a Republican. I don't know. You? Oh, me? Oh, I'm a Republican. Okay, there we go. Okay. All right. Well, my next question that I was coming with was, well, would that vote, the fact that you voted for him, lend more credibility? But since the fact that you didn't remember that, well, I don't think for you that would be a fair search. No, that wouldn't have any effect on you at all. The fact that you had voted for him, that you might tend to believe things that he might tell you more than anybody. Okay, all right, and then who else? I can't remember who else. You, sir, how about you? Would that have any effect? Okay, all right, so now when considering the evidence that you're going to be presented with, okay, and you think about whose burden, is there anyone who somehow believes that officers are more credible than any other person? Would anyone here believe an officer over a regular citizen? You wouldn't. Okay, and why is that?
I was raised to believe that officers upheld the law, you could trust him.
Mr. What number? I'm sorry, ma'am, I didn't quite get it.
I I believe you should be able to believe her.
So you would find yourself having a hard time not taking their word for what they're telling. Okay, all right, thank you, I appreciate it. Is there anyone else? In that, right, ma'am, could I hold your number? 30 seconds. Okay, go ahead, can I explain it?
I feel the same way. I went to the law enforcement, many departments and looking for it. And I also face the respect to the law.
There's gonna be an officer here who might be inclined to take their testimony for a higher rate than some of them. Even if you were instructed not to.
I would try not to, but I couldn't hear it.
Believe your mind. Anybody else? Yes, ma'am.
Those married my cousin, my husband, and I watched him.
Is he gonna be testifying here today? I mean, in this case? Okay. You're all right.
We didn't catch that, huh? Thank you, I will. So as it turns out, it doesn't look like your husband's going to testify, but nevertheless, we're going to go ahead and excuse you. Doesn't look like your husband's actually going to testify, but nevertheless, we're going to go ahead and excuse you. Yeah. That was what we were talking about.
Neary wire tower.
Why don't you tell us how to pronounce your last name? Warehouser, okay. Just like the big company, huh? I got you. Good. All right. So, Mr. Loomis, I think we'll have you just have a seat a second. If Mr. Loomis has questions of Mr. Warehouser, we'll let him go first.
Good afternoon, Mr. How are you doing? Good. I appreciate you being here. We had a lot of discussion about a lot of different topics. Is there anything that you think, as you sit here right now, about everything that was discussed earlier, or anything that Mr. Loos has discussed thus far, that it would make it difficult for you to be a fair and impartial juror in this case? Okay. Do you believe, Mr. Weyerhaeuser, that if you were selected as a juror, that you could sit, listen to all the evidence, and then make a decision that's just based on the evidence that's presented? Thank you. The state would pass this potential juror for cause, Your Honor.
All right, Mr. Loos, you can continue then.
Thank you. Well, sir, I know you came here late, but I'm sure you've been listening. Was there anything that anybody asked or said that you took violent exception with? Okay. All right. Now, how about you? Where I was last asking questions, it was about dealing with law enforcement and how your feelings would be toward their testimony, if you would give that greater weight than somebody else.
It probably would be.
Okay, all right, thank you, appreciate that. All right, just, only really have one question left, If something is a fact that it has happened. And the question comes to you. Somebody had to do it. Is that something that would make you search for the answer, or do you believe that your job is not to search for an answer, but to hear the evidence and grade the evidence? Anybody thinks they should be searching, trying to find it? So everyone would agree that that's your job, is to view the evidence that's presented. And then make decisions obviously on that, but to only look at the things that is presented. You're all right.
All right, good, thank you. So we're ready to go ahead and begin the strikes. And so council, take a moment while I explain to the jury what we're doing. For those of you in the back, you haven't been called up and you won't need to be called up. We're going to exercise strikes. In the case of this type, there are 10 strikes on each side. So it takes a while to go through that process, and we go one by one, alternating back and forth with the state, starting with the first defendant back and forth until we have 10 strikes. We will end up with a 12-member jury plus 2 alternates. And so when we're all done with that, I will release the rest of you, and then we'll begin with the process of what we have to do next, which is just some mere formalities at this point in time. But so if you would like to stand and stretch and visit quietly amongst yourselves, you may do that. Anybody in the far back, I don't want you to really leave the building, but if you need to use the restroom, you can come back in until I excuse you when you're done, if you want. So we'll let that go ahead and begin the process. So we're going to push that. Just kind of scratch. Which one's the one that has that best? Oh, you got another down. Okay. I'm okay. We'll just give them a chance. That's all right.
Random book.
They're just random, yeah.
It's only for, if you're
Um,
not pedal. Just
But a
an old singer.
regular working one or non-working?
Had it in my interweb for a year.
Maybe.
Tired of it. Really can let me
Why
know.
don't you do me a take a picture of it?
Okay.
That's the easiest way,
Yeah.
because we only have so much room and I always run it by, there's about two people, I always say, hey, this is available, what do you think? And then they'll say, but then, because that they know what we can use, they have sort of a vision of space, and things like that, so I'm real careful about it now, I used to just bring things, and they got low for that, so. But you need to check first, because some of these things, we have at our houses, and we would just bring them when we need them. And that's fine, but sometimes.
Yeah.
I had an opportunity on a Trendle, a foot pedal one. But I knew it was my sister-in-law's, it's not very good condition, I knew it would require some, significant work, and there wasn't a sewing machine in it, it was just a cabinet on the. And I thought maybe they'd want it, and they said, no. So I thought, okay. But it's worth asking, because strange, unique things like that, once in a while we'll have one, and we'll keep them forever. So.
It was just Jay's mom and his mom's, and I just didn't wanna give it away, and I'm like, but now he does, he does. He does.
I understand, I can relate to that.
So I don't sew, but it's heavy, so we didn't put it any further than hallway.
Into the hallway.
And so now it just has like, his baseball caps are on it and chest thing, and I'm like, I was looking at it last night.
Send me a picture, and that's what I'll do, is I'll share it with the people I know who can make that decision.
I think Steve put it on swap for like 200, went down to 100, went down to 50, went down to, I'll give it to you. Lady's like, no, I don't want it now.
Audrey is the one that we use for most of that, but she's in Rome right now,
Oh.
seeing her granddaughter. So. On 8 through preliminaries, we can actually do those before 4:30. Jobs done. And I might get to read those and see what we need to do, and then they'll sell tomorrow, right? Or by that. Said, well, it is kind of simple, but it's complicated. So that's what I know in place. Parts just finding that in place there. Kind of make me dizzy trying to keep that. Forget what it is. Yeah. Hasn't changed anything. Well. Initially, so the whole system's on. So I took it off. Check. When you tell them, she calls down to see if she can see us, she just saw me leaving. I mean, I erased those emails, but we should be good. People are not playing well together. No, that's gonna be a mess. Because he's gonna be for. I might use the same morning. Well. Gonna get crammed into November's gonna be ugly.
What are you thinking?
Status exercise, it's 10 times.
Okay, and I just ask if you briefly consult to make sure you share or concur in strikes so that there's no dispute about what strikes were exercised. And as long as you can tell me you're okay with that, I know you may have done that as you went along. I've only had that come up, I think, twice in my lifetime, and I don't want to have it come up again. One last question on the record. Do either of you want to make any record with regard to the jury strikes? Okay. Okay, I think then, okay, good. I think we're, yeah, all right, so. While they're double checking, those of you in the back are free to go. If you have a number, if you don't just leave it on the bench there, you can go when you go, but you hold tight just a second because that first row, we need to have you let go. Everybody else is free to leave. Thank you for your patience and your work today. You got it figured out, Jill? Okay. All right. So I'm going to have Jill, who's one of the two court attendants here, call out the names of those who have been selected to serve in the jury. So if you do that at this time.
Louisa Rhodes. Carrie. Braban. Ricky Mock. Sarah Stevenson. Randall Hearn. Haley Leofus. Margaret Wood, Alexis Sharp, Kelly Hess, Fidencia Gonzalez, Elizabeth Brown, Christopher Nehas, Linda Hamilton Downey, Maurice Byers.
That are 14?
Yes, sir.
Okay, good. If your name was not called, that means you are free to go. Go ahead and just leave your numbers on your seat is fine. We will collect them later. Be sure to get your things or your items if you have anything. So. Did I miss one here? 1, 2, 3, 4, 5, 6, 7, 8. I only got 13. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Who am I? Oh, I was not counting. Sure. Okay, good. I want to make sure. I was having trouble counting, apparently. Okay, in just a moment, folks, this is what's going to happen next. I'm going to place you under oath, so you're then sworn in as jurors in this case. And I want to not forget to let you know, I don't know what the weather's like tomorrow, and this courthouse is somewhat fickle in terms of temperature. So feel free if you want to bring a sweater, because sometimes it's cool in here, sometimes it's not. And I can never tell from day to day which it's going to be. So just be prepared for that if you would. Today's pretty comfortable, but when we're in this sort of time where it's warmer outside and colder outside at different times, it's sometimes the temperature inside here is a little more difficult. Also, if you want to bring something to drink, something from while you're serving, just as long as it's got a lid or a sealed top, so we don't have to worry about cleaning things up. I know I'm more attentive when I have something, and especially in the afternoon. So feel free to do that. You have my permission, and you can just do it without asking. Just make sure it's sealable or it has a lid or it's closed or can be for tomorrow and each day that we're serving. We're going to begin the evidence tomorrow, so we're not doing any evidence today, but what, Jill, where will you want them to check in tomorrow? Jill and Natasha. It's not just Jill. Jill's the one I've worked with the most. Natasha is our other young lady here who is assisting us, and either one of them you can approach if you have issues, concerns, or questions. But what?
We'll be meeting in the jury room right next door.
Okay, so what'll happen is you'll just come into the courthouse, come up to this floor in the jury room where you'll gather each time we take a break, and you'll work out of this very, very next door room right here, just as where I'm pointing. It'll be, there's a couple doors in there, and there's plenty of room in there, and that's where you'll meet, gather and during breaks or in the morning or at the return after lunch, et cetera, like that. And when deliberations begin, you'll likely stay in there as well. We started out with the second jury this morning, and that sometimes gives us pause about where we're going to be, but that's all over with, and we don't have to worry about that one. So you're the only ones here in this building this week. And I want to make sure, I know Cheryl, I think my court reporter told you about cell phones. So when we're in the courtroom, have them shut off. If there is a reason that you need to have them on for something like a medical emergency, or something's going on with a family member or something, I just need to know about that so I can be aware of how we can address it best. We want you to be attentive, obviously, for what's going on in the courtroom and pay careful attention to things. But if there is something going on that we need to know about, talk to me about that, or bring it to one of our court attendants' attention first, and then we'll address it the best way we know how. And so we will give you notepads and pencils tomorrow and a badge. So when you're on break, people will know you're jurors while you're in the courthouse. You don't have to take notes, but if you decide to take notes, I'm going to tell you now, and I'll probably remind you tomorrow, start any notes that you're going to take on the second page, but put your name on the front page, because we gather them at the end of the day and put them away in a cabinet and lock it so nobody looks at them, but that way it's whole lot easier if you just start on page 2 with your name only on the front page. Okay, so let me go ahead and I want to place you all under oath. So we have that completed before we're done here today. And we will then start in the morning with reading of preliminary instructions, the charge and the plea, and then opening arguments or opening statements, and then begin the evidence. So I'd ask that you each stand, if you would, in this case, please. I'm going to ask you to raise your right hand and ask that each of you solemnly swear that you will well and truly try the issues wherein the state of Iowa is the plaintiff, and Nathaniel John Parker III is the defendant, and that you will render a true verdict, and that you'll do so solely based upon the evidence introduced here in court and in consideration of the instructions of this court. Please answer, I will. Okay, thank you. All right, so gentlemen, anything we need to have these folks take up anymore today? I don't think so, unless you have something I'm not aware of. Okay. But here, oh, yes. Okay, yeah, good. Yeah, have a seat, just a second. I got ahead of myself. Well, that's important, isn't it? Well, we're gonna want to start at 9 o'clock. So I want you to hear maybe 10 till approximately. I wanted you to be aware of the fact that we do have, and I just thought of this, that's why I had to sit down. We're going to have a high school class that has been anxiously awaiting a time when we have a jury trial going on. They will be with us most all day tomorrow. They're supposed to be here so that they can be seated by 9 o'clock. And I think they'll be here most all day. Just want you to be aware of that. I'm aware of it, and we've had communications with the folks that are coordinating all that. And then finally, I am going to just read an admonition to you that I want to do just once. I'm going to do it once today, and then I'll refer to it every time we take a break in this fashion. I'll say, just keep in mind the previous admonition, or it's a caution. It's about how to conduct yourselves now that you've been selected as members of the jury in this case. So we're going to take a recess overnight, but before I do, I'm going to give you these instructions. I'm going to call them or refer to them as the admonition or the admonition to the jury. I won't give this to you every time we take a break, but I will refer to it. Until this case is finally submitted to you for your consideration and deliberations, and until you go into the jury room for those deliberations, you shouldn't talk with anyone about the case, including family members or anybody in the press or anybody that might approach you and want to visit about that. You may, of course, discuss things amongst yourselves, but I don't want you to talk about the evidence in this case, because that's actually beginning the deliberation process. Talk about anything else that you might want to, those kinds of things, but don't talk about the facts of this case, because, as I said, that would begin your deliberations and be premature. Don't talk to anyone else. Even if someone comes up and talks to you, tell them that you're a jury member in this case and that you can't talk to them. The judge has instructed me not to do that, is how you can tell them that. But if they persist or stand in your area and begin to talk about the case for some reason or another, please walk away. And if you can't do that, or if you feel it's important to report it, talk to me, Cheryl, Natasha, or Jill, and bring it to their attention, and I'll deal with it. Okay. Just want to make sure that that doesn't happen. We want you to make your decision entirely upon what you see and hear in this courtroom. And so it's your duty to keep those people at bay, if you will, or keep them away from you and not communicate with you about the particular case. And so if there's an attempt to do so, especially if someone doesn't listen to your response to not talk about it, then that's what I want to know about. I don't want you to visit or investigate the scene of any occurrence that might be referenced or discussed in this case, or conduct any tests or experiments, although I don't think that's likely, but nevertheless, we do this and we give this admonition in every case. You only do that if I allow you to do so or tell you to do so. You should not read, listen to, or view any newspaper, radio, or television reporting of this case. And we may have television and we may have newspaper here tomorrow as well, or for the duration of the case. Those reports are often prepared without adequate time to check the facts. They may be based on incomplete information, and they are sometimes inaccurate in very important respects. not criticizing the media, but they oftentimes don't have the whole story when they report portions of it. I'd rather you decide on what you see and hear in this courtroom than on news or media accounts. The purpose of these rules is to avoid you being influenced by certain information or opinions that are biased, incomplete, or inaccurate. You should determine the facts in this case by the evidence and the facts as seen, observed, and experienced here in this courtroom during trial. You should give careful attention to all the evidence, and that means when it starts and not stop until when it finishes. So it can go on for a few days here, as we've indicated. So pay as much attention to the first evidence you hear as the last evidence. From time to time during trial, we will take breaks as I may need to rule on legal or evidentiary arguments or objections. And in sustaining or overruling objections, I will apply the rules of evidence. The rules of evidence are utilized by court systems so that we determine and make determinations about evidence that is admissible or inadmissible. And the rules of evidence apply to evidence that may not be as reliable or may be suspect. And so we apply these rules of evidence to get you the best evidence possible under the circumstances and the evidence that's tested by the process of cross-examination and many other things that are part of our rules of evidence. So please understand that that's an essential part of what we do, and don't hold it against a party if they make an objection, and don't try to figure out what the answer would have been if I sustain the objection. Sustaining means I found the objection to be a valid one and the evidence or the question is not going to proceed further. If I overrule an objection, it means the evidence or the testimony can then come in. And I don't want you to draw any conclusions by the mere fact that a question was asked, especially in light of if I grant an objection or sustain it. In a case like this, the jury acts, I should say the jury is the judge of the facts and I am the judge of the law. I get to make rulings on law. You get to decide the facts. And that's how the case goes. At the end of the trial, I'll give you jury instructions and I will also have preliminary instructions for you at the beginning that will help you apply the law to the facts as it is presented and as you find it. It will be your duty to determine the facts in this case, apply the law, and reach a verdict. It may be necessary for me from time to time to recess and to hold a conference or meeting or a hearing outside your presence with the lawyers. This is also a very important aspect of what we do and how we do our business. Those conferences can sometimes be fairly lengthy, but I will do what I can to minimize those and consume as little as your time as possible. Please don't talk to the lawyers or anybody else, witness or the defendant in this particular case. They know they're not to speak with you. That keeps us at a distance. It keeps us neutral. It keeps us neutral fact finders and law determiners. It's necessary to avoid any appearance of any unfairness or improprieties by doing it in that manner. And the evidence in this case, as indicated earlier, is expected to take at least a couple of days. We should be done by Friday, I believe. And so don't form or express any opinions until you've heard all the evidence. Listen to the attorney's summaries of the evidence and their arguments at the end of the case. And don't make a decision until you go into the jury room and begin your deliberations. Above all, you should avoid doing anything that would be unfair to either party. And you should avoid doing things that might give the appearance of being unfair. The parties are here today because, of course, this case is very important to them. It must ultimately be decided by you. And you as the jury and I as the judge have a duty to give them as fair a trial as we possibly can. And so just want to make sure you understand how important that is. And the last thing I'll comment about is when you get home, if there's someone at home, and it doesn't matter if it's a husband, wife, brother, sister, significant other wants to know about this case, you tell them Judge Neary says, I can't talk about it until it's over with. And I know that's awkward, but because they're going to want to know, and they're going to want to know what you're experiencing. And some people have more interest than others, and they might want to find out what you learned today in court each day when you go home. It's important that you not have a conversation with them about that Because what happens is you begin to think about the evidence. They might start asking questions about what you think about this and what you think about that. And you see all of a sudden, you're in the process of making some determinations in your own mind about whether you believe or disbelieve somebody or some set of facts. I want you to do that as a jury, not individually until it's time. And so that's why it's important and rely on me. I can be the bad guy. That's how it should go. So, okay, if you haven't left your numbers, just go ahead and leave them on your seat. You're free to go. Keep in mind that admonition I gave you earlier, and we'll see you in the morning. All rise. The jury's excused for the day.